Ladies and gentlemen, if I could just have your attention, please, for a couple of minutes. Thank you very much. If you could all take a seat at your earliest convenience, that would be much appreciated. Welcome to this wonderful, wonderful ballroom here at the Savoy, and thank you all very much for being here. If I could start by asking our dignitaries that are going to be joining us up on stage to please make your way up onto the stage, please, before we get the proceedings started. Once again, if I could ask all of our dignitaries who will be joining us up on stage to please make their way up onto the stage. Fantastic. Okay, ladies and gentlemen, a very, very good morning to you and welcome to this, the prestigious second edition of the Arbitrating Indo-UK Commercial Disputes Conference, organized by the Indian Council of Arbitration. Of course, known as the ICA, it was established in the year 1965 as an arbitral body of national importance under the initiative of the Government of India and FICCI, the Apex Chamber of Commerce. Now, the main goal of the ICA is to promulgate amicable, quick decisions and inexpensive settlement of commercial disputes between the disputants utilizing arbitration. In the present scenario, ICA is not only leading arbitration, the only leading arbitration in India, but it is also playing a significant role as one of the most preferred and trusted arbitration centers in the Asia-Pacific region. My name is Amit Shana. I'll be your host for this afternoon and making sure hopefully things go very, very smoothly. But before we proceed any further, we'd also just like to acknowledge the honor to have the presence of the esteemed Honorable Miss Justice Hema Kohli, Judge Supreme Court of India, and Sri Arjun Ram Meghwal, the Honorable Union Minister of State for Law and Justice. Give them a big round of applause. In order to celebrate their presence this evening, I would like to ask our very own Mr. Arun Chawla, Director General of the Indian Council of Arbitration, to please present these dignitaries with a shawl as a token of our respect and admiration. If you could step forward. Fantastic. You could do better than that, ladies and gentlemen. Come on, a big round of applause. I know it's early. So on behalf of the ICA and FICCI, we are delighted to have you all here today, representing a diverse range of legal professionals, business leaders, members from the Bar of the UK and India, and other esteemed dignitaries from both India and the United Kingdom, and I'm sure far and wide across the country and the globe as well. Thank you all for being here. Another big round of applause, just to get you warmed up. So, ladies and gentlemen, to commence this remarkable event, it is my great honor to invite up to the stage a man whose vision and dedication has played a pivotal role in highlighting the importance of arbitration for commercial disputes in India, and it's been his continued endeavors to make India a preferred destination for international arbitration. Ladies and gentlemen, please put your hands together for the Director General of the Indian Council of Arbitration, Mr. Arun Chawla. Please give him a big round of applause.
Miss Justice Hema Kohli, Honorable Judge Supreme Court of India, Shri Arjun Ram Meghwal, Honorable Union Minister of Law and Justice, Government of India, Mr. Sujit Ghosh, Deputy High Commissioner of India to the UK, Mr. Harish Salve, King's Counsel, Blackstone Chambers, former Solicitor General of India, Ms. Geeta Luthra, Vice President, Indian Council of Arbitration. Ladies and gentlemen, what a privilege to have a galaxy of speakers on the dais, lending an appropriate stature to the conference. This conference, which is a significant platform to foster dialogue and collaboration between legal professionals and businesses from India and the UK. The conference, ladies and gentlemen, is in particular focusing on the crucial subject of international commercial arbitration and its key impact towards the growth in business and trade between both the nations. We are honored to have amongst us Honorable Ms. Justice Hema Kohli, an eminent judge of the Supreme Court. Justice Kohli, your landmark judgments in your entire judicial career, spanning over 17 years, has lent strength to the concept of fairness and justice in the judicial landscape of India. We welcome you. We are also honored by the presence of Shri Arjun Ram Meghwal, Honorable Minister, Ministry of Law and Justice, Government of India, someone who brings with him the tremendous experience of many other ministerial portfolios. Honorable Minister, your commitment to augmenting the great relations between India and UK is revealed by your ready acceptance to join this conference at a very short notice. A very warm welcome to you. Adding to the honor, ladies and gentlemen, we have Mr. Sujit Ghosh, Deputy High Commissioner of the Indian High Commission. The High Commission, as we all know, plays a pivotal role in strengthening the bilateral relations and economic ties between India and UK. Mr. Ghosh, we eagerly await your address, shedding light on the importance of collaboration in the legal areas between the two nations. Last but not least, someone who needs no introduction is Mr. Harish Salve, King's Counsel, a distinguished member of the Blackstone Chambers, and a former Solicitor General of India. I'm sure he will be able to provide a perspective from both the sides. Mr. Salve, your vast experience and exceptional legal acumen have made you a prominent figure in the international arbitration. Ladies and gentlemen, please join me in giving a thumping welcome to the dignitaries on the dais. Ladies and gentlemen, before we delve deeper into the discussions and listening to the vision of the luminaries on the dais, let me throw some light on the trade relations between India and UK, which have seen a steep upward trend in recent times. Economic trade and investment relationship between the two countries are thriving, with the trade at $17.47 billion US dollars, and investment flow from UK to India has been $31.90 billion US dollars in the past decade. The proposed free trade agreement is expected to help double the bilateral trade by 2030. This thriving business environment calls for a robust dispute resolution system, a legal environment which has cost-effective dispute resolution mechanism and provides opportunities for expeditious enforceability is most essential. In addition, there is a need to have qualified professionals with a global view advising and adjudicating matter for economic entities. In this regard, arbitration has emerged as an important alternate dispute resolution tool. The crown jewel of the slew of reforms is Bar Council of India's recent notification pertaining to the practice of foreign law firms and their regulation, the opening up of the Indian legal market for foreign lawyers to advise clients in the practice of foreign law, non-litigious matters, and international commercial arbitration is a welcome step. Additionally, this step, based on reciprocity, will go a long way in enhancing India's appeal as an arbitration hub. In order to keep up with the evolving times, Indian judicial system has made huge strides and placed a special focus on digitization and use of technology. Introduction of dedicated digital courts, conduct of hearings through virtual mode, mandatory e-filing, transparent publication of statistics of commercial courts are promising developments. The courts have also adopted a pro-arbitration stance. by referring matters filed before them to arbitral institutions of repute, underlining the importance of institutional arbitration. Further, in the changing business world and in view of the evolving needs and concerns, the Indian government and judiciary both have made several efforts to ease the justice mechanism. Relevant legal measures and systems have been initiated for an efficient outreach to justice delivery system. Today's conference, ladies and gentlemen, is a small contribution but a significant step to facilitate an informal conversation on the many opportunities and challenges of arbitrating Indo-UK commercial disputes and finding a way forward. Before I conclude, I cannot but fail to recognize a few distinguished guests whom I recognize, and some of them who are also contributing the thoughts in the panels ahead. Mr. Justice Hemant Gupta, former Supreme Court Judge and Chairperson, India International Arbitration Center. Ms. Pinky Anand, former Additional Solicitor General of India and Senior Advocate, Supreme Court of India. Mr. Nicholas Vinyal, King's Counsel, Chair of the Bar Council of England and Wales. Ms. Karishma Vora, Barrister and Arbitrator, 39 Essex Chambers. Honored also by the presence of two sitting judges of the Andhra Pradesh High Court, Justice Raghunandan Rao and Justice Sumaya Jalu. Also privileged by the presence of Mr. Chandra Iyer, Deputy High Commissioner of the British High Commission in India. My profuse apologies if I have not acknowledged many others who are distinguished in their own respective way, but I have not recognized them in this crowd. Lastly, my special thanks to the members of the media who have joined us to convey the message of the conference to a vast multitude of stakeholders who could not attend. Thank you.
Once again, thank you very much, Mr. Chawla there. A very inspiring set-off for this morning's proceedings and setting the stage of what promises to be a remarkable gathering of legal minds. And we are privileged to have you and all of you with us today. Once again, ladies and gentlemen, another big round of applause, please. So, next we have the distinguished presence of Mr. Sujit Ghosh. Now, Mr. Chawla, of course, gave a wonderful, wonderful introduction. The Deputy High Commissioner of the Indian High Commission here in the UK. As a representative of the Indian government, Mr. Ghosh holds a significant responsibility in fostering bilateral relationships and promoting socio-economic cooperation between our two nations. We eagerly await your address, Mr. Ghosh. Ladies and gentlemen, please, a big round of applause.
Justice Hema Kohli, Judge, Supreme Court of India, Minister Law and Justice, Shri Arjun Ram Meghwal, Shri Harish Salve, and other distinguished members of the panel, esteemed audience, a very good morning to all of you. The theme under discussion is a relevant one, and the organizers must be complimented for having drawn up a distinguished panel of experts to dwell on this theme. I am the lone outlier here, with no background or expertise on this subject. What I propose to do in the next few minutes is provide you with a quick snapshot of the rapid transformation which is underway in the India-UK bilateral economic and commercial landscape, and highlight how this reinforces the case for greater cooperation between the two sides to strengthen the arbitration ecosystem, which would hugely contribute to the ease of doing business in the India-UK economic corridor. India-UK ties over the years have transformed into a robust, multifaceted, and mutually beneficial partnership. During the India-UK summit in May 2021, Prime Minister Shri Narendra Modi and then UK Prime Minister Mr. Boris Johnson agreed to a new and transformational India-UK comprehensive strategic partnership and an ambitious India-UK roadmap 2030 to steer cooperation for the next 10 years. The trade and economic pillar of the India-UK partnership is a crucial one in the overall relationship with immense untapped potential. Just to revise some of the figures that the previous speaker quoted, India is the second largest source of FDI into the UK after the United States and has invested in 107 projects and created, just last year, 8,664 new jobs. And this is the figure from the Department of International Trade Investment Statistics 2021-22. The number of projects and jobs increased in comparison to 2021 figures of 99 projects and 4,800 plus jobs. As per the CII Grant Thornton India Meets UK Report 2022, there are 900 Indian companies operating in the UK with combined revenues of almost 54.4 billion UK pounds. Together, they paid over 304.6 million pounds in corporate tax and employed more than 140,000 people. This figure excludes employees of the UK branches of Indian companies. UK is the sixth largest investor to India, with a cumulative equity investment of US dollars 32.82 billion, accounting for around 5.3% of all FDI into India. India-UK bilateral trade, and here I include both goods and services, stood at 35.9 billion pounds during the year 2022, an increase of 45% or 11.2 billion pounds from 2021. From this, India's total imports from UK amounted to 15 billion pounds, and India's total exports to the UK amounted to 20.9 billion pounds. India was UK's 12th largest trading partner in this period, accounting for 2.1% of UK's total trade. With FTA in the works and once concluded, these figures are expected to skyrocket. As part of the roadmap, both sides continue to work on a slew of initiatives to foster cooperation in education, health, innovation, R&D, climate finance, defense production, cultural economy, people-to-people contacts, just to name and identify a few sectors. These efforts reflect the shared vision of nurturing a strong and vibrant relationship. India's robust economic performance in the middle of a global economic showdown is a result of the implementation of several economic policies and reforms in the last few years, which have ensured an investor-friendly environment. The Make in India initiative, ease of doing business reforms, and liberalization of foreign direct investment are examples of India's commitment to facilitating and attracting investments from the United Kingdom and other countries. In fact, 3 of the largest Asia-Pacific mergers and acquisitions that were closed in 2022 involved India. All 3 deals were domestic Indian transactions. The year before that, India's deal-making activity also saw scaling new heights, almost 600 deals valued at over $102 billion. As India speedily moves towards a USD 5 trillion economy in the next 3 to 4 years, it is expected that more heft would get added to our bilateral economic partnership. Robust arbitration frameworks play a pivotal role in ensuring fair and efficient resolution of commercial disputes. The landscape of commercial disputes in international arbitration is evolving rapidly. The emergence of new age challenges such as technology-related disputes, cross-border transactions, and complex contractual arrangements necessitate a dynamic approach to dispute resolution. International arbitration serves as an effective means to address these complexities and foster trust and confidence in international business transactions. As India works towards establishing itself as a major center for arbitration, it can learn from UK's experience. London has long established itself as a preferred arbitration seat. India, with its huge legal talent pool combined with its increasing weight in the global economy, has the right credentials to develop itself as a hub for international arbitration, incorporating modern practices and adapting to the changing demands of commercial disputes. Our legal system is responsive to the evolving needs of businesses and is equipped to handle complex and diverse arbitration cases. In India, the Arbitration and Conciliation Act has been amended to align with international best practices and streamline the enforcement process. Additionally, India is signatory to the New York Convention, which facilitates the enforcement of arbitral awards across borders. This reinforces the confidence of businesses engaging in commercial activities, especially between India and the UK. In July 2018, India and the UK entered into an MOU for promoting cooperation in the sphere of law and justice. A joint consultative committee was constituted to carry out objectives of the MOU. The last JCC meeting was held in August 2022, wherein both sides agreed to facilitate exchange of experience and best practices in areas like working of commercial courts, arbitration, and other dispute resolution mechanisms, use of technology in case management, and enforcement of contracts. In this context, I'm pleased to inform you that India has recently undertaken liberalization measures which have been designed to foster collaboration, knowledge sharing, and enhance cross-border legal services. Given all these positive developments, I'm hopeful that legal services sector cooperation between India and the UK will continue to grow. Thank you.
Thank you very much, Mr. Ghosh. Once again, ladies and gentlemen, as I'll continue with our distinguished panel here, we're honored to have with us a legal luminary, Mr. Harish Salve, KC. With an illustrious career spanning several decades, Mr. Salve has been a force to reckon with in the field of arbitration and law. As a former Solicitor General of India and an esteemed member of Blackstone Chambers, he brings unparalleled expertise and a wealth of experience. Ladies and gentlemen, please join me in extending a warm welcome to our very own Mr. Harish Salve as he graces us with his address. Thank you, sir.
Honorable Minister, Justice Kohli, Mr. Chawla, other friends on the dais, ladies and gentlemen. It's a matter of such delight to be here this morning in a seminar of this kind, a discussion of this kind, involving arbitrations between India and United Kingdom. And the reason I say so is arbitrations have covered quite a distance as a form of dispute resolution. In the 20 and more years I've had at the bar, I have seen international commercial arbitrations evolve from that enigmatic process which some lawyers indulged in Paris or in Geneva, very little London and no Singapore at that time, to a well-accepted, robust dispute resolution system which is seriously considered by the business community as not just the last clause dictated at midnight, but an important consideration, an important area of discussion, an important area of agreement when you sign a contract, whether it be for investment, partnership, technology transfer, or any other similar venture. The fact that FICCI is hosting this itself speaks volumes. When I began legal practice, which was a few years ago, I don't think my business clients ever worried about dispute resolution when they signed a contract. I don't think it was on the table. It was something which your lawyers would sort out as and when the occasion arose. Transnational dispute resolution was a dream. No businessman signing a transnational deal ever thought he would end up in a transnational dispute any more than a smoker thinks he will get cancer. And that's how this went on and led to a situation where one of the biggest concerns of foreign investors in India was, if we have a problem, how do we get it solved? The unilateral model adopted in India in 1996 and its journey over almost 2 decades shows that we were not ready in 1996 for this kind of a change. The change had to come from Parliament. I remember a first conference within weeks of the 1996 ordinance in Ahmedabad, and one of the leading practitioners, Mr. Dolakia, who was giving the speech, late Chief Justice Ahmadi was presiding, and he said, how can we have a law of this kind? How can we have a law in which awards are not challenged? How can we have an award in which arbitrators are appointed in this fashion? How can we have an award in which the court will not go into the merits of a dispute before appointing an arbitrator? That's the problem. The 96 law called for a change in mindset. We were not ready then. But yes, again, we have covered a distance, but we are still not there. I feel we still need more occasions like this where we can have an engagement between the stakeholders. Who are the stakeholders when we speak of arbitration? The first and the foremost, the parties. And you have Vicky leading this engagement today, because it's the commercial community which has realized one of the troubled areas, one of the areas which makes people doing business with India blink, is the prospect of litigation in India, and I make bold to say so. Today, if the UK courts have such a large amount of international disputes, many of the cases in the commercial court which we see here do not have even a single English party. They just have English law, and that's good enough. And why do people come here? That's what is the secret of seeing why is it that today the business community is willing to engage. They want a certain efficient in terms of time and efficient in terms of cost remedy to resolve disputes so that life can go on. Transnational trade doesn't brook delay in resolution of disputes, and that is what is the first and most important thing we need to discuss, we need to focus on. My experience tells me, of having worked now in both jurisdictions, what India needs is infusing the spirit of dispute resolution. Don't think of dispute resolution either as a way of avoiding your problems or worse, trying to buy time. And we have the privilege of having the law minister here. The single biggest litigant in India is the government of India. And the government of India and its entities engage in arbitration. And I think it would be a wonderful exercise if the Honorable Minister can ask his ministry to keep track of the performance of Indian public sector undertakings and the government departments in arbitrations. Lead the way. Show that the government takes arbitration dispute resolution seriously as Parliament has taken legislating for arbitration in India. The government has shown great alacrity in recent times in attending to legal problems in the arbitration law. And I'm sure one amendment is in the offing to set right the Supreme Court judgment which says an unstamped arbitration agreement cannot be relied upon. I think that needs to be fixed, and we don't have time for a larger bench to hear that. Maybe the Honorable Minister can have the matter examined and see if a change in the law is required to sort that out. But we need to infuse the spirit of arbitration. We need calibrated judicial oversight over arbitrations. Calibrated, not intrusive. We see that increasingly in the level at the level of the Supreme Court, how reluctant the court is to either interfere or to allow interference with the arbitral process. The high courts have yet to find a way. We have to find some way in which arbitration is not anymore the first step in a long dispute resolution process. Arbitration is a one-stop remedy, and except in extreme cases, the award has to be final. The third area where people from our fraternity need to work on is developing a specialist arbitration bar. You see it in London, you see it in other centers. There are lawyers who now work as a part of the arbitration bar, because an arbitration today has become a mix of a trial without the delays in a traditional trial process in a court. It is an effective, efficient trial mechanism where, as long as you stick broadly with the correct principles of evidence and the correct principles of natural justice, you are not expected to tick the boxes of procedural law. And that is where the bar has a very major role to play. And finally, we have to establish the supremacy of the commercial law. That is extremely important. People wonder why I say so. I say so because in 2005, I sat as an arbitrator with one of the very eminent English judges, and he was a retired judge of the Court of Appeal. And the first thing he told me was, the common law is read in tooth and law. The common law is read in tooth and claw was the first thing I learned from him. There is no sense of, I don't think this is reasonable. If there is a contract, carry it out. And I sat as an arbitrator in which we awarded a very large sum to, it just so happens, to a Government of India company, because Glencore's ship arrived 1 hour late. It arrived on 31st December. It crossed the line because the captain possibly was partying. It came on the 1st of January. The lay can kicked in. They got damages. Now, that is what he meant by the common law is read in tooth and claw. We have to have the supremacy of commercial law, not decide by the seat of our pants. The only solution, and over and above all this in India, the only solution for decluttering our courts is to find more and more arbitration and less litigation. I've noticed we have some excellent technical sessions that follow, and I'm sure a lot of these points will be picked up by all the experts who are going to be participating. The journey has begun. We have come a distance. Now it's for all of us as stakeholders to sit together, to put our minds together and see how, like UK has become, like London has become, we make India the next hub for legal tourism in our part of the world. Thank you.
Thank you very much, Mr. Harish Salve, KC, King's Counsel, of course, wise words and lots to be discussed and debated throughout this morning. Well, ladies and gentlemen, as you have heard many times this morning, we have the distinct honor of welcoming the Honorable Union Minister of Law and Justice for the Government of India. His esteemed presence at this conference reflects the unwavering commitment of the Indian government for highlighting the robust and efficient legal framework for commercial dispute resolution. Ladies and gentlemen, please welcome up on stage the Honorable Shri Arjun Ram Meghwal.
International Conference on Arbitrating Indo-Uk Commercial Disputes, second editions. And on this occasion, on the dais, Justice Hema Kohli ji, the Judge of Supreme Court of India, and Harish Salve ji, and Sujit Ghosh, and Geeta Luthra ji, and Arun Chawla ji, Director General of India. I think Arun Chawla ji DG of two posts, Director General of FICCI and Director General of ICI. Oh, 1 and 2. Very good, Chawla ji. On your request, I am here. All the partners of law firms in UK and India and esteemed members of Indian Council of Arbitrations and other arbitral bodies, ladies and gentlemen, I stand before you today with immense pride and gratitude as we gather for the second edition of the Conference on Arbitrating Indo-UK Commercial Disputes. This event serves as a platform to foster collaboration, exchange knowledge, and promote the use of alternate dispute resolution mechanism. That is the importance for which we are here. Alternate dispute resolution mechanism in resolving commercial disputes between our nations. The Indian government, under the visionary leadership of Prime Minister Narendra Modi ji, recognizes the critical role that a robust legal framework and efficient dispute resolution mechanism play in promoting business growth and nurturing a conducive investment environment. Today, I have the privilege of sharing with you the key development initiated by the government to strengthen our judiciary and alternate dispute resolution mechanism. Again, I am reiterating the important and core topic is alternate dispute resolution mechanism. First and foremost, I would like to thank the Indian Council of Arbitrations, duly supported by the Federation of Indian Chambers of Commerce and Industry, for inviting me to address this eminent congregations. The Indian Council of Arbitrations provides world-class arbitration at its facilities in cost-effective manner and has been a leading arbitration institution at the forefront of support institutional arbitration in India. The Council has been providing arbitration services for both domestic and international commercial disputes and provides required administrative support in the smooth conduct of arbitral proceedings. Also, the Federation of Indian Chamber of Commerce and Industry, of which ICA, as an allied body, is a body representing the corporates and industry in India. It has been actively participating and associating itself in providing inputs and suggestions for policy discussions, inter alia relating to the improvement in dispute resolution mechanism in India. The successful functioning of Indian Council of Arbitration is largely due to active support of the Federation. As we know, trade, industry, commerce and investment can only thrive when the state policy provides a conducive business environment to the stakeholders, along with a robust dispute resolution mechanism. Both the area have been accorded due priority by the Government of India under the able leadership of Honorable Prime Minister Sri Narendra Modi ji. In this regard, Honorable Prime Minister is one of the speeches especially highlights the role and importance of arbitration, which I quote. Businesses seeks assurance of the prevalence of rule of law in the Indian market. They need to be assured that the rules of game will not change overnight in an arbitrary fashion, and that commercial disputes will be resolved efficiently. A robust legal framework backed by a vibrant bilaterals, culturals is essential. Thus, theme for the present conference, arbitrating Indo-UK commercial disputes in this background is most topical and relevant. Before speaking about the reform that have been undertaken by the Government of India in strengthening the ADR mechanism, I would first like to recall about the India's role in laying the foundation of the giving due recognitions to the foreign arbitral awards. India was amongst the only the sixth Asian nations to have signed the Geneva Conventions on execution of the foreign arbitral awards of 1927. Later, it was amongst the 10 original signatories to New York Conventions on the recognition and enforcement of the foreign arbitral awards and ratified the convention in 1960. Thus, we have since long committed ourselves to keep pace with the global development in the field of arbitrations. Hence, to carry forward this legacy, the Government of India, under the able leadership and guidance of Honorable Prime Minister, has taken various steps and measures towards revitalizing and strengthening the contract enforcement and commercial dispute resolution regime to enable ease of doing business and boost investor confidence. Thus, the present requirement and future needs have guided the reform in the ADR regimes, which an objective which includes. It's very important. Number one, to make ADR as the preferred mode for the dispute resolution, especially commercial disputes. Second, to facilitate a paradigm shift from ad hoc arbitrations to international arbitrations. Third, to minimize court intervention and to facilitate arbitration-friendly approach among the courts. Fourth, to bring India at par with other jurisdictions in the arena of ADR mechanism. Fifth, to change foreign investors' perceptions about India's arbitration regime and to develop India as a hub of international commercial arbitrations. In order to provide a quick and robust system for resolution of commercial dispute, the Government of India is working on the vision of the Honorable PM, which is more focused on providing a robust alternative dispute resolution ecosystem and strengthening the traditional dispute resolution centers. Courts, in pursuance of the visions, major legislative initiations have been taken by the Government of India during the last 9 years to provide for effective contracts engagement enforcement regimes. As a consequence, far-reaching legal reform, which not only caters to investors' comfort level, but also ease the burden on courts, have been initiated inter alia, which aims to promote India globally as an arbitration hub. The Commercial Court Act 2015, Honorable Harish Salveji is reiterated that the importance of the commercial court. To fast track adjudications of commercial dispute, the Commercial Court Act 2015 was enacted, which facilitated establishment of the commercial courts and the commercial appellate court at the district level and commercial division and commercial appellate division in high courts. The special jurisdiction relating to the commercial dispute is aimed at ensuring timely disposal of commercial disputes without straining the resources and capacity of the stakeholder. The subsequent amendment in the year 2018 to the Commercial Court Act 2015 introduced mandatory pre-institutions mediation and settlement for suits which do not contemplate any urgent interim relief. The introduction of compulsory pre-institutions mediations is aimed at providing an opportunity to the parties at dispute to resolve the commercial dispute outside the ambit of the court through mediation. In the country, there are more than 1,000 commercial courts established in India, Establishment of these courts has facilitated faster resolutions of disputes. The benefit of providing commercial courts has resulted into disposal of a commercial dispute in approximately 400 days, which is far less in comparison to the earlier period of the 1,445 days. Amendment to the Arbitration and Conciliation Act 1996 we have done, which has been, I think, referred by the Salveji also. I would like to highlight the certain significant amendment carried out in the Act, which includes provision have been incorporated relating to the confidentiality of the arbitral proceedings along with the immunity to the arbitrator for any actions taken in good faith. It was the major demand. Ground for the challenge to arbitrator have been detailed out and specified per prevalent international practice to uphold independence, independence and disparity of arbitrations. Statutory framework for time-bound completion of arbitration proceedings and separate provisions for fast-track arbitration have been introduced. So many initiations we have taken in this connection. India International Arbitration Center is an again area, the Government of India, the India International Arbitration Center Act 2019 provides for the establishment of an institution of national importance, namely the India International Arbitration Center, for creating an independent and autonomous body for facilitating the institutional arbitrations. The AISC shall internalize provides facilities and administrative assistance for conciliation, mediation, arbitration proceeding, maintain and panel of the arbitrator, both of national and international level. Promote research and study, provide teaching and training and organize, I think, the conference and seminar for awareness also. Introduction of the Mediation Bill 2021, again it is a major change with the arbitration has been the mainstay of alternative dispute resolution in India. The ADR ecosystem is undergoing change from time to time to keep pace with the global trend. These are the major initiatives the Government of India has taken. Framing of Bar Council of India rules for registration and regulation of foreign lawyers of foreign law firms in India 2022. It was also a major initiation as taken by the Government of India. I am sure the endeavor of BCI will further strengthen the cooperations between both the countries in the area of legal services and result in mutual benefit to stakeholders, both the countries. Currently, India has assumed the presidency of G20, which will culminate with the holding of G20 summit this year. As we know, the G20 nations, of which India is a founding member, hold a strategic role in securing future global economic growth and prosperity. To achieve this objective, a continuous exercise required in the respective jurisdiction interlinked to the strengthen enforcement of contracts and related alternative dispute resolution mechanism. Such measure will promote increased economic and financial cooperation among the various countries. In this background, I am confident that the Indo-UK relations, especially in area of the trade and commerce, are bound to take a leap forward in the coming years. I think I would like to end by once again thanking the ICA and FICCI for inviting me to this event and wish that the discourse and the discussions that happen during the conference will leave the participant enriched and equipped with the confidence that dispute resolution mechanism in India and United Kingdom are vibrant, efficient, and consistent. In conclusion, I would like to express my gratitude to the Indian Council of Arbitrations for organizing this remarkable conference, bringing together experts, practitioners, and stakeholders from India and the United Kingdom together. Let us leverage our collective knowledge and experience to explore new avenue of cooperation and strengthen the bond between our nations. I wish all the participants of this conference a happy learning and deliberations, and I am confident that our discussions and deliberation will contribute to the advancement of arbitration as a preferred mode of resolving Indo-UK commercial disputes. Before concluding, today is the World Environment Day. For that, I want to say something because this is because we are in the process of the presidency of G20. So we have given the motto: one Earth, one family, and one future. That is also good motto for this conference also. Thank you very much.
Thank you, sir. Thank you very much. Right, ladies and gentlemen, we have the privilege of welcoming another distinguished guest who has made remarkable contributions to the Indian judiciary. It is with immense pleasure that we introduce the Honourable Miss Justice Hema Kohli, a judge of the Supreme Court of India. And her presence among us today signifies the importance that the Indian judiciary places on alternative dispute resolution mechanisms, particularly arbitration, and in ensuring effective and just resolution of commercial disputes. And of course, as always, we look forward to her keynote address. Ladies and gentlemen, big round of applause.
A very good morning to Mr. Megwal, Minister of State for Law and Justice, Mr. Justice Hemant Gupta, former judge of the Supreme Court and chairperson of the Indian International Arbitration Center, Mr. Sujit Ghosh, Mr. Salve, Mr. Arun Chawla, Ms. Geeta Luthra, and distinguished guests and friends from the legal fraternity, both from the United Kingdoms and India, ladies and gentlemen, friends from the media. I'm delighted to address the esteemed gathering on the topic of the day, arbitration Indo-UK commercial disputes in a vibrant city of London. But I'm starting with some trepidation, and don't be surprised if I'm repetitive when we have such distinguished speakers preceding me who have touched almost all the subjects that one had on one's mind. Please do bear with some repetition. India and the United Kingdom share a common bond rooted in the common law system. The common law heritage that both the countries share is embedded in the underlying fabric that weaves through their legal systems. Both the countries have established enduring legal frameworks for arbitration that are fundamental to their legal systems. It is a remarkable coincidence that the Arbitration and Conciliation Act 1996 and the Arbitration Act 1996 were legislated in India and the United Kingdom, respectively, almost contemporaneously. Both the acts emphasize party autonomy, minimal judicial interference, and finality of the arbitral awards. These features form the bedrock of legislative frameworks of both the jurisdictions. Arbitration and mediation are facets of the ADR regime and have evolved tremendously from their humble beginnings and are now an ubiquitous force in the legal industry across the globe. A multitude of noteworthy developments are currently shaping the prevailing outlook on arbitration and mediation. I take this opportunity to share with you my insights on India's transformation into a global hub of international arbitration, driven by the judiciary's unwavering commitment to providing a finality to the arbitration awards and fostering a pro-enforcement regime. India has, as you all know, a rich cultural heritage, diverse economy, and a robust legal system, making it an ideal destination for international commercial arbitration resolution. In recent years, India has made significant strides in establishing itself as a reliable partner in arbitration and mediation services. There's a clear commitment to providing a fair and an impartial environment for dispute resolution. And the Indian judiciary is actively working to ensure that fairness, efficiency, and enforceability of the awards. Through investment in legal infrastructure and partnerships with leading institutions, India's stature as a center for excellence for arbitration and mediation is set to rise and see new heights. A key milestone in India's aspiration of becoming an international hub of arbitration was the enactment of the Arbitration and Conciliation Act, a legislation, as we all know, is based on the UNCITRAL model laws and rules. The Act has consolidated and amended laws relating to domestic arbitration, to international commercial and arbitration, to enforcement of foreign arbitral awards, and has also defined the law relating to conciliation. So a modern and comprehensive legal framework for arbitration came to be introduced in India. The object was to align our laws with international standards, give full effect to the economic reforms that were taking place in India, and to facilitate the growth of arbitration as a preferred mode of dispute resolution for both domestic and international parties. So what have been the approach of the courts in India to underscore the finality of an arbitral award, to tighten the enforcement regime? I'll give you a couple of examples. In a landmark case of Balco versus Kesar Aluminium, the Supreme Court of India had affirmed the pro-enforcement stance of the Indian courts. It had observed that the Indian judiciary should adopt a minimal intervention approach while dealing with arbitral awards. The judgment emphasized that courts should not act as appellate authority and reassess the merits of an arbitral award unless there are compelling reasons to set it aside. The judgment sent a strong message to the international business community that India is committed to upholding the sanctity of arbitral awards. In a recent case of 2020, the Vijay Karya case, a 3-judges bench of the Supreme Court of India had underscored the importance of giving due regard to party autonomy in the arbitral process, the competence clause. The court adopted a pro-enforcement outlook while holding that mere contravention of provisions of, in that case, the Indian Exchange Control Laws, FEMA, and the regulations would not tantamount to contravention of the Act. The court ruled that violation of a legal principle of law would only be considered against India's fundamental policy if it goes against a basic principle that cannot be compromised. It further observed that fundamental policy refers to the core values of India's public policy as a nation, which may find expression not only in these statutes, but also in the time-honored, haloed principles that courts follow. Incidentally, the Act, as originally crafted, had used the expression "in conflict with public policy of India" as one of the grounds for challenging an award under the concerned provision, Section 34. This had spewed a whole lot of litigation, and parties had approached the courts challenging the awards by arguing that an expansive meaning ought to be given to the expression. It was in 2015 that the provision was amended, and substituted expression used was "in contravention with the fundamental policy of Indian law." So the decision in Vijay Karya's case further solidified the pro-enforcement regime and the approach of the Indian courts, and instilled a confidence in parties engaging in international cross-border commercial arbitrations in India. Coming to institutional arbitration in India and mediation in India, recognizing the needs for specialized institutions to administer international arbitrations, India has witnessed the establishment and growth of several arbitration centers. Some of the most prominent centers that have emerged as preferred destinations for arbitration include the Indian Council for Arbitration in Delhi, the Mumbai Center for International Arbitration in Mumbai, the Delhi International Arbitration Center in Delhi, the Indian Chamber of Commerce in Council of Arbitration in Kolkata, the International Arbitration and Mediation Center at Hyderabad. In 2019, the central government had established the New Delhi International Arbitration Center, an autonomous organization that specializes in arbitration, in mediation, and conciliation procedures. Its primary object was to establish an independent and self-governing framework for institutional arbitration. And recently, Justice Hemant Gupta, who's amidst us today, has been appointed as a chairperson of the NDIAC, and he'll be moderating the third technical session for you to understand how it'll work henceforth. The arbitration centers strive for efficiency, for transparency, and impartiality, providing high quality of arbitral services to parties involved in domestic and international commercial disputes. Located in rapidly growing cities like New Delhi in the north, Mumbai in the west coast, Calcutta in the east coast, and Hyderabad in the southern part of India, these centers provide efficient, cost-effective, and innovative methods for resolving commercial and legal conflicts, such as MEDARB, ARB-MEDARB processes, and many others. Currently, the Arbitration and Conciliation Act of 1996 includes conciliation in its provisions, but as the Law Minister just pointed out, there is no specific law on mediation so far in our country. In contrast to countries such as Australia, Singapore, and Italy, India is still in the process of developing a separate legislation for mediation. In this regard, the proposed mediation bill of 2021 is a significant piece of legislation aimed at promoting mediation, at emphasizing institutional mediation, and establishing a process to enforce mediated settlement agreements, which is most imperative. The bill provides a strong legal foundation for mediation in India, recognizing its importance in dispute resolution. The bill mandates mediation referrals, ensures confidentiality, and outlines the role and qualifications of mediators. Ultimately, this framework will enhance the efficacy and efficiency of mediation as an ADR process in India. Presently, the bill stands referred to the Standing Committee on Personnel, Public Grievances, Law and Justice, and is expected to be presented in the Parliament in the near future. What are the recent reforms to enhance the efficiency and effectiveness of the statute? Some of the amendments have been touched upon by the Honorable Minister. These amendments to the Indian legislature, that the Indian legislature was wanting to align with the needs and expectations of the stakeholders, would be evident from the fact that the Act, a cornerstone of the Indian arbitration framework, has undergone significant amendments in 2016, 2019, and 2021. These amendments, propelled by a progressive vision and a commitment to fostering a robust arbitration ecosystem, was enacted with the overarching purpose of addressing key lacunae, aligning India's arbitration laws with international best practices and promoting a pro-arbitration regime that inspires confidence in resolution of commercial disputes efficiently and in a time-bound manner. In 2016, India's arbitration landscape saw significant improvements with the introduction of the 2016 amendment. The amendment aimed to improve efficiency and efficacy of the arbitration proceedings by implementing time-bound procedures to streamline the process and ensure prompt dispute resolution. It strengthened the hands of the courts in dealing with dilatory tactics, with discouraging unnecessary delays and affirming India's commitment to an efficient arbitration regime. Building upon the foundations laid by the 16 Amendment, the 2019 Amendment sought to rectify specific international issues and address practical challenges faced in implementing the Act. The 19 Amendment was significant in that it established the Arbitration Council of India that would be responsible for improving professionalism in arbitration and in helping with selection of impartial arbitrators. By clarifying the interim measures can be ordered by arbitral tribunals only during the process and not thereafter, the amendment is aimed at minimizing uncertainty and improving the enforceability of arbitral awards, which in turn would inspire confidence in the global business. Most recently, in 2021, the Act underwent further amendments. The recent 21 amendments to the process is aimed at addressing new challenges, improving its effectiveness. These changes are directed towards promoting institutional arbitration, ensuring confidentiality during the proceedings, and impartiality in appointment of arbitrators. So, by aligning the Indian laws with international standards, these amendments have greatly improved the arbitration process. Coming to the aspect of entry of foreign law firms in India that has been touched upon just before me, recently in March 2023, the Bar Council of India has released the rules for registration and regulation of foreign lawyers and foreign law firms in India. The regulatory body in India now permits foreign lawyers and law firms to practice, but only in specific areas and on a reciprocal basis. These firms can establish offices in India to provide guidance to clients on matters like mergers and acquisitions, intellectual property, joint ventures, and contract drafting. As of now, they cannot represent clients before any court or a regulatory authority. This move, no doubt, will provide opportunities for the young talent to compete with peers in the West and enable Indian law firms to learn from global best practices. Additionally, these regulations will help address concerns about the influx of foreign direct investment and establish India as a hub for international commercial arbitration. It is worth noting that India boasts of the largest number of English-speaking common law educated lawyers worldwide. These advantages make India a truly attractive destination for legal professionals and business houses. What has been the impact of COVID-19 pandemic on ADR, a subject which all of us have dealt with and have really had experiences hands-on. The COVID-19 pandemic had caused a worldwide crisis that had impacted every aspect of life, including the legal system in India. In our country, the pandemic had led to changes in the judicial system, including moving towards the online dispute resolution, ODR, like virtual arbitration and virtual mediation. But it's important to remember that the human involvement is still crucial in these processes. To adapt to the online environment, arbitrators and mediators must improve their skills. Use of digitization not only makes the arbitration process more efficient, it also ensures that important records are easily accessible and less likely to be lost or damaged. The Indian courts ought to be acknowledged for accepting digital records of filing. The use of digital records has made enforcement of awards more efficient, reduced the burden of evidence in courts. The courts in India have really adapted to the challenges of pandemic by accepting digital records and virtual hearings, ensuring that arbitration and other ADR processes could continue uninterrupted. This enables timely resolution of disputes and of upholding contractual commitments. The trend towards digitization and virtual proceedings is a positive step forward. To conclude, India has all the potential to establish itself as a leading choice for international arbitration and mediation. It boasts of a progressive legislative framework, a pro-enforcement judiciary, and a robust institutional support. Some work is still under progress, and work in progress means something positive to my mind. And I would be the first one to concede that there's some things have to be done to mend ways and approaches in handling arbitration matters from the point of start to the end. By using digital technology, court and ADR, including arbitration proceedings, can now be conducted online from any location, making physical distances irrelevant. India fully appreciates the significance of international cooperation and collaboration in arbitration in an era of interdependence, of affiliations and affinities characterized by cross-border transactions and FDIs. Only in July 2018, the India and UK governments had signed an MOU to enhance cooperation in law and justice. As a part of the agreement, I understand a joint consultative committee was established to identify areas of cooperation and develop plans to achieve this goal. As recently as in August 22, a progress has been made towards achieving these objects. So, the common law system that forms the foundation of legal frameworks both in India and in the United Kingdom serves as a unifying factor that promotes collaboration, sharing of knowledge, and building strong networks between legal professionals from both jurisdictions, like today's platform. The legislations and the judicial precedents in the field not only shed light on convergence of common legal principles, but also underscores the unwavering commitment of both the nations to provide a fertile ground to enable arbitration to flourish as a prominent and well-accepted mode of ADR. By leveraging their shared legal heritage and principles, India and the United Kingdom can surely shape the future of dispute resolution, drawing from the strengths of the common law system and their commitment to fairness, efficiency, enforceability, and the rule of law. The proliferation of a collaborative mindset between Indian and London institutions that promote ADR culture would greatly be beneficial for further development in this field. I hope that India's continued effort to align its arbitration framework with international best practices further strengthens its position in this field. Ultimately, it's the mindset and a positive approach towards dispute resolution that matters. Thank you.
A huge thank you to Justice Hema Kohli there. A real pleasure to hear you speak. Right, the last of our speakers for this morning session, we have the Vice President of the Indian Council of Arbitration and a Senior Advocate of the Supreme Court of India. Ladies and gentlemen, please welcome up on stage Miss Geeta Luthra, whose vast knowledge and experience in the field of arbitration makes her a true authority on the subject. Of course, all anticipating hearing from her this morning before we take a short break. Ladies and gentlemen, please, your hands together for Ms. Geeta Luthra.
Good morning to all. We've been very fortunate because even the UK weather has been welcoming of the ICA and our conference. Honorable Justice Hema Kohli, Honorable Justice Hemant Gupta, who now wears another hat in addition to his earlier hat, Honorable Mr. Arun Chawla, Director General FICCI, Advisor ICA, Mr. Sujit Ghosh, Deputy High Commissioner of India to the UK, Mr. Harish Salve, KC Blackstone Chambers, former Solicitor General of India, who needs no introduction at all. My colleagues who are here and who are chairing various sessions, Ms. Pinky Anand, former Additional Solicitor General of India, Supreme Court Advocate, Ms. Karisma Vora, Tejas Karya, Mr. Ganesh Chandru, Mr. Sanjeev Kapoor, and all member of the governing body of ICA, my various colleagues from the legal fraternity, ladies and gentlemen, I have the most pleasant task as Vice President of the Indian Council of Arbitration to thank each and every one of you for taking out time and being here with us today. Justice Hema Kohli, with the vast experience she has, first at the bar, and we would see her scurrying from court to court as NDMC Standing Counsel and in various other hats, has taken the task of being one of the most erudite judges of the Delhi High Court, thereafter Chief Justice Andhra Pradesh, thereafter now Supreme Court judge, and has decided various matters with regard to arbitration. She has decided UHL Power Company. She has decided a judgment in future coupons versus Amazon. So she is fittingly the keynote address speaker in this function. And I thank her deeply for being here with us today. Mr. Harish Salve, who is an indomitable presence. We miss him in India, but because of the advantage of the online platforms, we do see him more than ever, an omnipotent presence on the arbitration scene, on the litigation scene in India. Mr. Salve has been the counsel in some of the most leading arbitration judgments in India and internationally, the Vodafone versus Union of India judgment, the Vedanta versus Union of India dispute, the Cyrus Investment versus Tata Sons, and we can take note of what he is saying, that we do need in India a very, very committed arbitration bar. And while addressing about Mr. Salve, I must say that what he said was that we need an arbitration bar, but what was said perhaps by the Honorable Minister as well as by Justice Colley was this, that what we need also is committed arbitrators, impartial arbitrators, and I believe that that also is equally important with an arbitration bar. We need arbitrators of impeccable quality. Now, insofar as the Honorable Minister, I would be remiss in my duty if I do not welcome the Honorable Minister, who's added color in more ways than one, and perspective to our black and white lives and to our black and white world. He has been a pillar of support to our London conference, coming in and being there. We were waiting with bated breath for his arrival, and we are very thankful to him. I also want to thank Mr. Sujit Ghosh for being there. He was there last year in our conference. He's there again this year, and he's been a great support, and I look forward to more and more interaction, and he's been completely cooperative all the time in the various conferences that we've had, and has been a citadel for us. I want to echo the words of Mr. Salve, but in my words. He said that arbitration is time efficient. Arbitration inspires confidence because it is about party autonomy, the right to choose your law, the right to choose its seat, the right to choose your arbitrator, the right to control the calendar and timelines of the proceedings, and that is why arbitration is the preferred option. If arbitration is the preferred choice, then I believe institutional arbitration is the icing on the cake. Justice Colley spoke about mediation and the mediation bill of 2021. I think that's very important because alternate dispute resolution has various stages and various steps. It includes conciliation, it includes mediation, it ends with arbitration. And thus, we have to look at this aspect, which will be the way for the future, and India is making great strides in that. Mr. Salve spoke about NN Global and the fact that unstamped arbitration agreements may be a step backwards, and that perhaps Parliament may redress that. Now, I can't say this as a lawyer. We've seen how the courts have gone up, down through SMS, NN Global first, other judgments, and let's see what happens. But to some extent, we can look at the judgment on unstamped agreements not being recognized as with an arbitration clause as something which would not be expansive of arbitration, and that's why I feel that that's very important. But one of the judgments that I have found extremely laudatory and is the ONGC Alphonse judgment. And that was about fixing of arbitrators' fees. One of the aspects in India which I felt was holding people back, at least in very big commercial arbitrations, or was starting to hold them back. And I'm glad the way has gone forward again, is the fixing of fees and the fact that there will be a maximum fee. And we can see the position in the UK, we can see the position in Singapore. The registrar and the Supreme Court can interfere, parties' liabilities can be determined by court, and so where there can be a review. So we have to have a mix and match of both. Indian arbitration has really made strides. As Justice Kohli said, it's a work in progress, and Vidya Drolia was truly the work in progress, actually showing that how the Supreme Court's interpretation has been more and more expansive. And therefore, even in some intellectual property disputes which were earlier considered not a domain of arbitration, the Supreme Court has now laid the law by Vidya Drolia as well as by other judgments. Reference was made to Vijay. I do not wish to repeat what all the learned speakers have said. It's been extremely erudite. We have 3 sessions which are coming up before us, deferred to by the keynote speaker, Justice Kohli, that the Indian legal market opens up. Are India and UK ready? I can tell you that a lot of law firms in India are looking at it with trepidation. I don't know what will ultimately happen and whether the Bar Council really will go forward with it and with what restrictions. But surely there is trepidation, but I think we have to welcome competition in whichever way it comes. The other 2 subjects have already been dilated upon. All that I can say is that international arbitration is definitely a substitution of many burning questions. And today's sessions, we will discuss, I believe, some of the important aspects of those burning questions. Thank you so much. Thank you to the media. Thank you to the organizers. Thank you to the ICA team. And if I have missed out anyone, let me apologize, but say a very, very grateful thank you for being here for the sessions and for this conference. Thank you so much.
Thank you once again to Ms. Geeta Luthra, the Vice President of the Indian Council of Arbitration and Senior Advocate of the Supreme Court of India. Thank you very much. Ladies and gentlemen, before I let you go, could I ask you please to all stand so we could take a group photograph of all of our wonderful speakers for this morning. Thank you very much. Once again, a big, big round of applause for all of our wonderful speakers this morning. So, ladies and gentlemen, before I let you go and have our very short break, which will take place in the River Room upstairs that many of you came through, I just want to let you know that round about 11:30 this morning, there will be a fire drill test. It will last for 2 minutes. Don't panic. Don't grab your bags. You don't have to leave just yet. If it lasts longer than 2 minutes, then begin to panic. But for now, it will happen at about 11:30 this morning. So if we could ask everyone to make their way back into the room just after that so we can begin again at 11:35. Thank you very much, ladies and gentlemen.